I may ask some questions to Justice Abdullah. Now, before the case of Re Tantleff, in the case of Re CFG Peru Investments in September 2021, the Singapore High Court has also recognized a US Chapter 11 plan and confirmation order under the model law. But Re Tantleff is significant because it's the first reported decision in Singapore which delve into the details and basis of recognition. Now, Justice Abdullah, you referred to two possible bases of recognition. That's Article 2H and Article 21(1)G, and you preferred to rely on Article 21(1)G. Just going back to Article 2H and the definition of foreign proceeding, in your mind, Justice Abdullah, do you think that Article 2H, the definition of foreign proceeding, includes foreign processes which have already concluded, but thereafter parties are still at liberty to apply to court for directions or relief? I just want to hear your views on that, Justice Abdullah.
Yeah, thank you. Yes, I think the reluctance I had about invoking 2H as the basis in Aedit Abdullah I'm still trying to consider the parameters, and I am concerned usually with unintended consequences of interpretation or laying down a specific approach. So in essence, I thought, based on the arguments available or made before me, I thought it was preferable to invoke Article 21 in terms of for recognition rather than 2H. This is not to say that I am not going to be persuaded at some point to invoke 2H. It's just really trying to consider the parameters and what might flow if I were to say that foreign proceedings should be interpreted in a particular way, or that it can actually cover, for example, Chapter 11 proceedings, even post the determination of a plan under Chapter 11. So I would regard the point as open, and that I would welcome practitioners to make the appropriate arguments when the opportunity presents itself. I should point out, both Justice Ramesh and I think, welcome the arguments leading to our respective decisions, mine in Tantleff and Justice Ramesh in his decision in relation to the China fisheries restructuring. The point of it is we don't come into proceedings with a set view as such. We remain open to being persuaded in either direction. And I recall even last year, I had one of your colleagues trying to make an argument for recognition of, I think, can't remember what it was, Australian superannuation orders in relation to some mining company. I think I did entertain the arguments, at least to some extent, although the matter was eventually discontinued. So it is possible, I think, to make out an argument under 2H, but whoever it is will have to satisfy me that any pronouncement I make doesn't have unintended consequences, that, for example, I may actually open the door for an interminable recognition of ongoing proceedings without any definition, or, for example, that leads to a abrogation of Singaporean jurisdiction and handing everything over to the control of a foreign court, which I think is beyond the scope of the model law. So some of these thoughts in my mind may actually turn out to be phantoms. So yes, you can persuade me that I am otherwise mistaken, and it's possible to use Article 2H in the same way. Turning then to the use of Article 21, I think what attracted me more to utilizing that was particularly the availability of safeguards in, I think, 22, in addition as well, of course, to the kind of backstop protection in terms of our public policy exception under Article 6. There could be a question whether I could use Article 6 once I've invoked Article 2H. I don't know whether, again, that's another phantom in my head, but that was another factor that kind of pushed me towards utilizing Article 21H instead. Sorry, Article 21 instead. Thanks.
Yeah, thanks, Justice Abdullah.